All right, looks like we have everybody here. So I will go ahead and start. All right, welcome everyone to the BMZA zoning docket for today, January 25th, 2022. For those of you who are new or this is your first time to a virtual docket, my name is Katie Byrne. I'm the executive director of the BMZA, and I essentially moderate this, run the Webex, and assist the chair however I can in moving the docket forward. James Fields is our chair. Jay Bonner is a board member. Bill Cunningham is a board member. And Sabrina Turner is a board member. Mr. French, who you can also see visible on your camera, is our representative from planning. We also have two attorneys assisting us today that are also panelists, Greg Fox and Becky Witt. All right, so those are the introductions. So I just want to go through a little bit on how Webex functions. If you've signed into the internet, you're considered an attendee. So right now you can't mute or unmute yourself. You can't turn your camera on. But you will see a microphone and additional buttons at the bottom and different options. So when your case is called, I will make you a panelist and unmute you. If your camera is functional, you can turn your camera on and we'll be able to see you. Those who call in and wish to testify, I'll go through the call-in users. You'll hear me say, okay, I'm going to the call-in users now. When you hear two beeps, please speak up as soon as possible to let me know that you are there for the case that we are discussing. If I don't hear anything, then I'll move on to the next caller. If you're unable to connect via audio, please use the chat feature. If a speaker is inaudible, they will be directed to call back. Please do not use the Q&A. I can only monitor one of those two at a time, and the chat feature is much easier to use, so we use the chat feature. If you'd like to testify in support or opposition of a matter, there are two ways that you can testify. Using the chat, identify what case number you're here for, whether you're in support or opposition. There's also a hand you can raise that will let me know when you wish to testify. Please do not raise your hand until the matter you wish to testify on is called. The order of testimony for the appeal will go as follows. The applicant goes first, followed by any support, then opposition, and then the applicant gets the last word and testimony will close. Anyone speaking on any matter before the board is considered to be testifying under oath and required to speak the whole truth and nothing but the truth. If you have any issues with WebEx, please call our office at 410-396-4301. Someone will respond and help you with whatever issues you're having. If you're still having technical difficulties, cannot participate, you may send an email explaining what those technical difficulties were at bmza@baltimorecity.gov. Cases will be called by the chair and we will proceed through the entire docket. Please note, your case may not be called in the order on which it appears on the agenda, so please be alert. And at this time, I'll turn it over to Mr. Fields, our chair, to start the docket. Oh,
James,
you're muted.
I pulled a Katie. All right, let's take your name off of that. I've done that before. Once we hear your case, we will endeavor to render a decision on it at the end of the docket in our deliberation period. You cannot participate in that portion of the hearing, but you can certainly listen in and hear the deliberation. I think on today's docket, we may have just one contested matter. There are a couple of, before I get to that, you will receive your resolution in the mail within about 30 days. You can certainly contact the BMZA office to get a heads up on what that decision was. Number is 410-396-4301. In any event, we ask that you not take any action towards your project until you receive your decision, and certainly don't do any building or construction or move forward on your project without securing the proper Baltimore City permits. So I was about to say we have a couple matters that are on the docket that are either postponed or withdrawn. Katie, you didn't mention this, right? Okay. We have case number 2021-286, 2330 East Fairmount Avenue. The appellant is Adam Carballo. That matter has been postponed. So if you're here for that matter, it will not go forward. Second postponed case is case number 2021-292. It's 3818 Roland Avenue. The appellant there is Roland Avenue Holdings, LLC. That matter will not be heard today. And finally, we have case number 2021-294, 6504 Armstrong Avenue. Tommy McDuffie is the appellant. That matter has been withdrawn. Right? We have a fairly lengthy consent docket today. Those of you who are unfamiliar, consent matters are those matters for which the board believes it has sufficient information to approve the appeal. So we've received all the information associated with the case and have determined that it would be appropriate to grant approval to it. So I will call those cases, hear any reports we have from planning and staff, and the appellant will have an opportunity to add anything he or she would like to the record, and then we'll dispose of those cases. And so I will commence with calling of the consent docket. First case we have is case number 2021-274, 502 Radnor Avenue. The appellant is Whitney Gishel, and this matter seeks variances necessary to construct a rear sunroom addition. I'll hear any reports we have from planning and staff.
Thank you. Martin French for the Baltimore City Planning Department. The Planning Department has no comment on this application.
Thank you.
The applicant submitted a request for a minimum rear yard setback and a lot coverage variance. They're attaching a rear yard sunroom addition to an existing dwelling in an R6 district. The minimum rear yard setback, 25 feet is required, 5 feet is proposed, so it's a 20-foot variance to rear yard. Maximum lot coverage variance, 45% is required, 67% is proposed, so it's a 22% lot coverage variance. And let's see, I'm looking for Miss Gishel. I do not see Whitney Gishel, so I will go through the call-in users now. If you are here for, let me just make sure this one, let me look at this, see if there's one person here. Nope, that's not them. So as I go through the call-in users, if you are here for 2021-274 502 Radnor Avenue, please speak up after you hear 2 beeps. Okay, moving to the next caller.
Hello.
Hello, are you here for Radnor?
Carol Martinez.
I don't think so.
No, okay. Let's try the next one. Okay, going to the next caller. Going to the next caller. Going to the last caller. Okay, so if you are here for 502 Radnor, please either raise your hand or put something in the chat. Maybe we can try to come back to this one at the end then.
Sure. All right. Moving on to the next case on the docket, case number 2021-278, 1419 Andre Street. The appellant is Marnie Smith, and this matter addresses variances necessary to construct a second floor rear deck and rooftop deck. And I'll hear any reports from planning and staff.
Planning Department has no comment on this application. Thank you.
Okay, the applicant is seeking to construct a deck at the second floor rear to provide access to a new rooftop deck in R8. Minimum rear yard setback is 20 feet is required, 1 foot is proposed, so it's a 19-foot setback requested. The neighbor has no issues with proposed deck construction. So I don't think anybody else is here to attend the hearing. So let me find Miss Smith. There she is. I'll make her a panelist.
Hi, I'm here. Thank you.
Good afternoon, Ms. Smith. Ma'am, is there anything you'd like to add to your application at this time?
Nope, I think I'm all set.
All right, very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you so much. I appreciate it.
All right, have a great day.
You too.
Right, case number 2021-280, 3022 East Fayette Street. The appellant is Praful Patel. This matter addresses variances necessary to construct a third-story addition, use the building as a multifamily dwelling with 3 units. And I'll hear any reports from planning and staff.
Planning Department has no comment on this application. Thank you.
Again, this is to construct a third floor addition to use as a multifamily dwelling consisting of 4 DUs and an R8. So the variances requested are off-street parking, 4 spaces are required, 3 spaces proposed. So they need a variance for 1 off-street parking. And I will get Mr. Patel here and make him a panelist. Mr. Patel? See, you're unmuted, sir.
Yeah, I'm here.
Okay, very well. Mr. Patel, sir, is there anything you'd like to add to your application at this time?
Is it for 280, right? The last.
This is this is 280, yes.
Correct.
3022 East Fayette.
No, we don't have, because I mean, just my client want to add, the 3rd floor, and then we have ample parking there, and then we are just adding. Actually, there is a little problem with the the application, because my application is called for the 4 unit, and basement, 1st floor, 2nd floor, and 3rd floor. But somehow, on that the docket, I think it says only about 2 unit, I think.
It says 3 units. So I believe that's what's in our application before us. Kenny, you want to
No,
check that?
actually, I
Yeah.
have the application, whatever I gave it to them, it's a 4 DU.
Right, I have 4 DUs and it's a
Oh, okay.
3rd floor addition.
Right. Okay, yeah, that's fine then. Yep, that's correct. I'm sorry.
That's okay.
Yeah.
And then just to confirm, you only need a variance for 1 parking because you're going to do 3 on site, correct?
Yes.
Okay.
Great. Well, assuming all that's clear and correct, can tell you that the board, having heard your appeal, Mr. Patel, we believe we have sufficient information to approve your appeal. Thank you, sir.
Oh, appreciate it. Thank you very much, sir.
All right, have a good day. Case number 2021-281, 1639 North Washington Street. The appellant is Glenis Brown Wade, and this matter addresses variances necessary to construct a 2nd-story rear addition, use the building as a multifamily dwelling with 2 units. And I'll hear reports from planning and staff.
Thank you. Planning Department has reviewed this application, noted that this property is in the Broadway East Urban Renewal Plan area. This proposal is consistent with that urban renewal plan. The department has no objections to approval. Thank you.
Thank you, sir.
There are 3 variances required for the proposed addition as 2nd floor and rear. The first one is a minimum lot area variance. 1,500 square feet is required, 1,200 square feet is proposed. So it's a 300 square foot variance request. Minimum interior side yard variance, 10 feet is required, 0 is proposed. So it's a full 10-foot variance for interior side yard. Minimum rear yard variance, 25 feet is required, 8 feet is proposed, 17-foot variance requested. So I've got Miss Glenis Brown Wade. I'll make her a panelist. Miss Wade, you're unmuted.
Yes,
Good afternoon, ma'am.
yes.
How are you?
Hi.
I just have one question for you. Is there anything you'd like to add to your application at this time?
Not at this time. Thank you so much for your time.
All righty. Happily, the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you. Thank you so
Right.
much.
Good luck to you. I'm going to call 2 cases at the same time. They're on the same street, different addresses with the same appellant. Case number 2021-282, which is 921 North Crescent Street. Robin Horry is the appellant, and that matter addresses variances necessary to construct a two-story rear addition. And also case number 2021-283, 923 North Crescent Street, same appellant, Robin Horry, and also that seeks variances necessary to construct a two-story rear addition. And I'll hear reports from planning and staff with regard to those two matters.
Thank you. Planning Department has reviewed both applications and has no objection to either one.
Thank you, sir.
Okay, before I get into the staff review, I don't see Robin Horry here on our attendee list. So if you are here on behalf of 2021-282 and 2021-283, please raise your hand. And let's see. All right, for either raise your hand or put in the chat that you wish to testify on this as the applicant. So let's start with the description. 2021-282, 921 North Crescent. It's an addition, first and second floor of existing semi-detached dwelling in R4. Minimum rear yard setback, 25 feet is required, 21 feet proposed, 4-foot variance requested to rear yard setback. Interior side yard setback, non-party wall, 15 feet is required, 9 feet 8 inches proposed. So it's a 5-foot 4-inch variance that's being requested. Minimum lot coverage variance, 35% required, 81% proposed. So it's a 46% variance requested. Now for the adjoining property, very similar. Minimum, so this one is 2021-283, 923 North Crescent. Minimum rear yard setback, 25 feet is required, 21 proposed, 4-foot variance requested. Interior side yard setback, again, non-party wall, 15 feet required, 9 feet 8 inches proposed. So it's again another 5-foot 4-inch variance requested. Maximum lot coverage, 35% required, 81% proposed. So again, same 46% variance for lot coverage. All right, so let's see what we got for some hand raising. Oh, wait, Mr. Holland. All right, so Mr. Holland, I'm going to make you a panelist. Mr. Holland, are you here for these two matters?
Yeah, no, ma'am. Can you hear me?
I can. So you're not here for Crescent? You're here for something
Well,
else?
No, ma'am. I was having technical difficulties. I was the very first person on the docket. So I'll just hang on until the very end and I guess we'll address, but I'm able to now participate. I apologize for that inconvenience.
No worries. Mr. Holland, what I'm going to do is I'm just going to mute you, let you hang out here as a panelist. When we're finished with these two, we can recall your case.
I appreciate that. Thank you, ma'am.
All right, so that doesn't help me with Crescent. So let's go through the call-in users for the 2 Crescent Street properties. So again, we're going to go through the call-in users. If you are here for 921 and 923 North Crescent, please speak up. Okay, I'm going to go to the next caller then. Hello, are you here for Crescent? Nope. All right, next caller. No, going to the next caller.
Yeah, I'm sorry. Alice. So, Alice.
Are you here for Crescent Street? I don't think so.
Sounds like a
The next one. All right, going to the next caller. 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 And this is our last caller. All right, so it doesn't appear we have anybody here for the 2 Crescent Street properties. I do not see any other hands. No one's put anything else in the chat, so maybe we'll try to recall these 2 at the end.
Okay, let's head back to the first one, case on the docket, case number 2021-274, 502 Radnor Avenue. Whitney Gishel is the appellant, but I hear that Steve Holland will be here on behalf of the appellant. Again, this matter addresses variances necessary to construct a rear sunroom addition.
Mr. Holland?
Hello?
Yeah, Mr. Holland,
Yes, sir.
okay, with regard to 502 Radnor Avenue, is there anything you'd like to add to the application on behalf of the appellant today?
No, sir. I just had one quick question. When I was listening to the review, it said that the lot coverage would be at 67%. And I have an email that shows it at 57%. So I just wanted a quick clarification on that.
Okay, so if you want to amend it to have less lot coverage, we
Yes,
can
ma'am.
do that. So I don't know if that error was on our end or what was in the application. So you're saying the proposed is 57%, not 67%.
That's just an email that I have. Yes, ma'am. But if it holds up the process, again, I know you guys are busy and it's been a couple of months, but yes, ma'am, it looks like it says 57%. So I guess the difference would be 12.
Okay, yep, no worries. We can, since you're actually asking for less, we can,
Right.
we can
That's a
scroll
lot
it
easier.
down. That's an easy
Okay,
one.
maybe that might be a help.
All right. Well, thank you for that additional input, Mr. Holland. But let me just tell you that the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so
Thank
much.
you, sir. I appreciate your help.
All righty. You take care, sir.
Well, I'll let everyone know, and per what you said, about 30 days for approval or for notification.
Very well. Thank you.
Thank you, sir.
All righty. Moving on to case number 2021-284, 2505 Fate Avenue. Matt Nofel is the appellant, and this matter addresses variances necessary to construct a 2-story rear addition with rooftop deck. I'll hear any reports from planning and staff.
Planning Department has no comment on this application. Thank you.
Again, 2-story rear addition, rooftop deck in an R8 district. There's a rear yard setback requirements and a lot coverage variance requirement. So minimum rear yard setback, 20 feet is required, 19 is proposed. So it's a 1-foot variance request. Maximum lot coverage is 60% is required, 76 is proposed. So it's 16% variance is requested. So I have Mr. Nofel, and I'll make him a panelist. Okay, Mr. Nofel, you're unmuted.
Yes.
Good afternoon, Mr. Nofel. Is there anything you'd like to add to your application today, sir?
No, there's not.
Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal.
And it looks like, Mr. Nofel, you're on the next one, so I'll just keep you here in the panelist queue.
Okay.
Very good. Call in case number 2021-285, 1413 William Street. Again, the appellant is Matt Nofel. And this matter addresses variances necessary to construct a 1st, 2nd, and 3rd floor addition with rooftop deck. Now, here are the reports we have from planning and staff.
Planning Department has no comment on this application. Thank you.
The only variance required is maximum lot coverage variance. 60% is required, 74% is proposed, so it's a 14% lot coverage variance that's being requested.
All right. And same question, Mr. Nofel, for this property. Is there anything you'd like to add to your application at this time?
No, there's not.
All right. Again, the board, having heard your appeal, I believe we have sufficient information to approve your appeal. Thanks so much.
Thank you very much.
Okay, great day. On case number 2021-287, 225 South Chester Street. Todd H. Lawrence is the appellant. This matter addresses variances necessary to construct a 2nd floor rear addition. Now, here are any reports we have from planning and staff.
Planning Department has no comment on this application. Thank you.
For the addition, 2 variances are required. Maximum lot coverage variance and an interior side yard setback. For the lot coverage variance, 35% is required, 71% is proposed, so it's a 36% variance. For lot coverage, minimum interior side yard setback, 10 foot is required, 2.5 feet proposed, 7.5 foot variance is requested. And I'll find Mr. Lawrence. And Mr. Lawrence, I've just made you a panelist and you are unmuted.
Okay, Mr. Lawrence, is there anything you'd like to add to your application today, sir?
No, there is not.
All righty. Well, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you.
Thank you very much.
All righty. Have a great day. Moving on to case number 2021-289. 249 South Chester Street. Henrietta Kahn is the appellant. And this application seeks to use the premises as a multifamily dwelling with 3 units. And I'll hear from planning and staff.
Thank you. Planning Department has no objection to approval of this application.
Thank you, Mr. Rich.
Let's see, there are 2 variances required. The variances required to use the property is a 3 dwelling unit multifamily dwelling. Currently, it is a 2 dwelling unit and multifamily, as is permitted in R6. Lot area variance 1,875 square feet is required. 994 square feet is proposed. So 881 square foot variance for lot area. Off-street parking variances, it's 1 space is required, 0 is proposed, so it's a 1 space variant for parking for the additional dwelling unit. And I've got Ms. Khan here. I think she's calling in from the phone, so I'm going to unmute her. Ms. Khan?
Yes.
Good afternoon, Ms. Khan. Thank you for appearing today. Ma'am, is there anything you'd like to add to your application at this time?
No, and thank you so much for your help.
All righty. Well, you're welcome for that. And I can tell you that the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you so much.
All right. Have a great day, ma'am. Case number 2021-290, 1409 through 1411 Pressman Street. William Hemby is the appellant, and this application seeks to consolidate 1409 through 1411 Pressman Street and use premises as a community center. Now hear from planning and staff.
Planning Department has reviewed this application and is recommending approval. Thank you.
Thank you.
Go. To use the properties as a community center in an R8 zone. First, conditional use. So in order to use it as a community center, the board must grant it as a conditional use. And then there are 3 variances required. We have a lot area variance, 3,000 square feet is required. 1,537.5 square feet is proposed. So the variance requested is 1,462.5 square feet. Maximum lot coverage variance. So that's lot area variance. This is maximum lot coverage variance. 70% or less is required. 81% is proposed. So and it's 11% lot coverage variance request. And parking. There's 1 parking space per 10 persons. There was nothing necessarily that was put in for parking or capacity. So at this point, we do not believe there is a parking variance requested. Just wanted to reiterate that 1 parking space is required per 10 persons of capacity. More than likely, they won't know their capacity until the fire department gets out there. So this may or may not have to come back for parking, whether or not they have enough on site. As far as additional research, we have an email from Ms. Inez Robb stating that the following associations are in support of the application: Sandtown Winchester Condo Association, Fulton Community Association, and Western District Community Relations Council. And if anybody knows Ms. Inez Robb, you know she knows everybody on the west side. So let's see. So Mr. William Hembley, there we are. Mr. Hembley. Mr. Hembley, it's not letting me unmute you. or make you a panelist. So it might be how you are connected. So but I think you should be able to use the chat, sir. So if you could put in the chat anything you'd like to add to your application, let's try that. Or if you could put in the chat if you're on the phone, and I'll go through the call-in users as well. So while we're hoping Mr. Emily can use the chat feature, I'll go through the call-in users.
All right, and he could just say yes or no in response to the question. Is there anything you'd like to add to your application? That may shorten it some if you can communicate via chat. Thanks.
So we're going through for, oh, hold on.
Heard a beat.
All right. Well, I've got, let's see, Bernard Warren. So Mr. Warren, I think I might be able to get you to unmute. Yeah. So Mr. Warren, I just made you a panelist. So Mr. Warren, are you here on behalf of 2021-290?
I am.
Okay, excellent.
Great. All right, Mr. Warren, thank you. Sir, is there anything you'd like to add to the application on behalf of the appellant today?
No, it's not.
All right, very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
Righty, have a good day.
You too.
Right. Case number 2021-291, 6204 Northwood Drive. Lydia Harris is the appellant. And this application seeks to use the ground floor of the premises as a daycare center for up to 12 children. I'll hear from planning and staff.
Thank you. Planning Department reviewed this application, noted this would provide an additional service for the neighborhood served by the York Road Community Action Plan area, and is recommending approval of the application.
All righty.
So again, the matter that's before the board is as a conditional use daycare. We have no opposition on the record. Last authorized use was as a single family dwelling. Applicant says she is currently using the property as a daycare. You can have an in-home daycare without, I think, up to a certain number of kids without having to get that conditional use. But let's see, Ms. Harris, I'm making you a panelist and you're unmuted, ma'am.
Hello.
Good afternoon, ma'am.
Good afternoon.
Is there anything you'd like to add to your application today, ma'am?
No, not at this time.
All right, very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so
Thank
much.
you. Thank you.
Okay, 1, 2. Let's go to case number 2021-296, 3402 Clark's Lane. Itzhak Lubavitch is the appellant. This matter addresses variances necessary to construct a rear addition. Now, here any reports we have from planning and staff.
Planning Department has no comment on this application. Thank you.
Okay. So conditional use is required. Oh, wait, wrong one. Sorry. Conditional use and variances to construct an addition to an existing place of worship. So conditional use, expanding of a conditional use. It's already conditional use for a place of worship, so it's going to be an expansion of that existing use. Variance is required, front yard setback, 40 feet is required, 21 feet is proposed, so it's a 19-foot variance. Interior side yard setback, 15 is required, 12 feet is proposed, so it's a 3-foot variance. And then off-street parking, 27 spaces are required, 26 are proposed, so it's a 1-spot variant. The Cross Country Improvement Association has put in a letter of support, and we have 3 letters of support from neighbors. So I'm going to find the applicant. 1 second. I've got Itzhak Lubavitch for Clark's Lane. If you are here for Clark's Lane, please raise your hand or put in the chat. I'm going to begin to go through. Oh, wait, I have Carla Ryan. I'm going to see. Ms. Ryan, are you here for this application?
Yes, I am. I'm here on behalf of the congregation.
Okay, I'm going to make you a panelist.
Thank you.
All right, you can go ahead.
All right, good afternoon, Ms. Ryan. Thank you for checking in. Is there anything you'd like to add to the application on behalf of the applicant today?
No, nothing to add. Thank you.
Very well. The board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thanks so much.
Thank you very much.
Okay, luck to you all. Now calling case number 2021-297, 617 South Luzerne. The appellant is Adam Carballo, and this application is a conditional use to construct a fourth floor, increase the maximum height of the dwelling to 41 feet. And I'll hear from planning and staff. Any reports we may have.
Planning Department has no objection to this application. Thank you.
So this is one of those funky ones in the code that it has a conditional use standard to increase the maximum height of a dwelling. So the request is to increase the maximum height of the dwelling for 41 feet in an R8 district. So I've got Mr. Carballo, and we'll make him a panelist. Mr. Carballo?
Hello.
Good afternoon, Mr. Carballo. Sir, is there anything you'd like to add to your application today?
No, sir.
Very well. The board having heard your appeal, we believe we have sufficient information to approve your appeal. Thanks so much.
Thank you. Thank you.
Great day. All right. Case number 2021-298, 4128 through 4136 Park Heights Avenue. Dapinder Singh Gill is the appellant, and this application seeks to use the premises as a motor vehicle service and repair minor with a fully enclosed structure. And I'll hear from planning and staff.
Thank you. Planning Department reviewed this application, noted that this is in the Park Heights Urban Renewal Plan area. The Urban Renewal Plan does not restrict continuing use of the property as a non-conforming use. It was last authorized for motor vehicle service and repair minor in a fully enclosed structure. The department has no objection to approval of this application on that basis. Thank you.
Thank you, Mr. Renner.
Again, it's conditional use auto repair and body shop. This request is to continue as a non-conforming use. The community petition with signatures in support of the application, letter of support in the file from Park Lane Neighborhoods Association. Land use cards, property seems to have been consistently used as an auto body and repair shop since the 1980s. No evidence of abandonment or non-conforming use in the file. So I'm going to, I don't see Mr. Gill here in the list. Let me see, let me go all the way back up to the beginning again. If you are here to testify as the applicant on this matter, either please raise your hand or put it in the chat. I'm going to begin to go through the call-in users. All right, so no. Let's start with call-in user. Unmute. All right, moving to the next call-in user. Going to the next call-in user. All right, going to the next caller. Going to the next caller. And the next caller, again, this is for 4128, 4136 Park Heights Avenue. Next caller. Going to the next caller. And that was my last caller. So we'll try to get a hold of Mr. Gill.
Okay. Keep moving. Case number 2021-298. Wait a minute, that's the one we just did. 2021-299, 2901 North Rogers Avenue. Linnea Anderson is the appellant, and this application seeks variances necessary to construct a 6-foot fence. Now, here are any reports from planning and staff.
Planning Department has reviewed this application and has no comment on it. Thank you.
Mhm.
Katie, you're muted.
Yeah, Becky picked up right off the bat when she hollered at me through the wall. So that's excellent job there. All right. So variance is required to install 6-foot privacy fence along a side lot line. Side yard variance 20 feet. Fences over 3.5 feet tall are required for the variance. So it's a side yard variance of 20 feet, and there's no opposition now. Miss Anderson, let me see. I think she was trying, I have an email from Roxana that she was trying to call in and could not get in. I don't see her here, but I'm going to go through the call-in users. So we'll see. So Miss Anderson, if you are here as a call-in user, when you hear the 2 beeps, please speak up. All right, moving to the next caller. All right, moving to the next caller. All right, moving to the next caller.
Hello.
Hello?
Hello.
Miss Anderson?
Hi. Yes, Anderson.
Excellent.
All right. Good deal. Good afternoon, Ms. Anderson.
Good afternoon.
Okay, so we're here on 2901 North Rogers Avenue, and my only question for you is there anything you'd like to add to your application at this time?
I'm in the need of the fence. I have people walking through my yard to get across to the front, throwing trash and running back and forth through. I think that's why I wanted the fence, so people won't be walking back and forth in my yard.
Okay, understood. All right, well, I can tell you that the board, having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
All right, thank you.
All right, have a good day, ma'am.
All right.
Okay, skipping over 300. Case number 2021-305, 1611 North Patterson Park Avenue. Noelia Carroll is the appellant, and this application seeks variances necessary to construct a 13-foot by 20-foot carport in the rear yard. I'll hear from planning and staff.
Planning Department has no comment on this application. Thank you.
There are two variances requested. Rear yard setback, 20 feet is required, 0 is proposed, so it's the full 20-foot variance. Maximum lot coverage, 80% is the maximum, 100% is proposed. Just noting that this carport has already been constructed, but we have no opposition on the record. I do not see Ms. Carroll here or Mr. and Mrs. Carroll listed in as a attendee, so I'm going to go once again through the call-in users. If you are here for 21305 1611 North Patterson Park Avenue, please speak up when you hear 2 beeps.
Hello.
Hello, are you here for 1611 North Patterson Park?
Yo translator por español, Spanish.
No.
Not have a Spanish interpreter here on site.
Hablo un poquito de español.
All right, we have someone who can speak a little bit.
Solamente un poquito.
Sí. Solo queríamos saber si había aceptado los planos y del deck, si lo vamos a remover o está bien así como lo dejaron el ingeniero.
All right,
So
can you get that?
No, part of it he wants to know if the plans are okay, but the rest of it I didn't get.
Okay.
Or something. Yeah, I'm no good for this.
I do have Roxana here as an attendee, so maybe if I could get Roxana unmuted. Let's see. Hold on, sir, 1 second. Let me see if I can unmute Roxana. Roxana?
Can you hear me?
Yes.
Okay, perfect.
Can you help?
Yes, absolutely.
Okay, Roxana, as you know, all I want to know from the applicant is whether or not there's anything you'd like to add to the application, since we've already reviewed it and have tentatively approved it.
Okay, all right, let me, señora Carol.
Sí.
Sí. Lo que Mr. Fields quiere saber es si usted quiere agregar algo a la aplicación porque técnicamente ya su aplicación fue aprobada, pero él por cortesía nada más quiere saber si hay algo que usted quiera agregar.
No, gracias, le agradezco todo. Para mí todo está bien, no queremos agregar nada más. Solo tengo una pregunta.
Ajá.
De la otra casa.
Oh, teníamos una corte en la 23-21. Queríamos saber si
Si vamos a tener un día de corte, porque nosotros pedimos un día de corte para esa casa, para una también algo que hay que repararle, pero no hemos recibido el día de corte.
Mire, para eso yo le llamo, eso no tiene algo que ver, o esto nosotros no sabemos, pero yo ahorita le llamo.
Gracias.
Ok, gracias.
De nada. So, no, they just want to say thank you.
Right. You are welcome. The board having heard your appeal, we believe we have sufficient information to approve your appeal. You can communicate that to them and we'll be good.
Okay, entonces el board ya tiene la información suficiente y le quiere comunicar que su apelación ha sido aprobada.
Gracias, muchas gracias.
All right. You're welcome, ma'am. I did get that. So very good. So let's see. Case number 2021-309, 612 Washington Boulevard, 27 Gems LLC is the appellant. And this application seeks to use a portion of the ground floor as a neighborhood commercial establishment, a spa and boutique. And I'll hear any reports from planning and staff.
Thank you. Planning Department reviewed this application, noted that this property is improved with a building that was in fact rehabbed and renovated with approval from the Commission for Historical and Architectural Preservation a few years back. It is in the Ridgely Delight Historic District. And for that reason, the Planning Department is recommending approval, subject to condition, that all exterior changes, including any additions, demolitions, alterations, and signage, are completed or installed in accordance with an authorization to proceed issued by the Commission for Historical and Architectural Preservation. Thank you.
Thank you, Mr. Friend.
There's essentially the one request is conditional use as neighborhood commercial. We have letters in support in the file for Ridgely's Delight Neighborhood Association and a nearby neighbor. And I will find, let's see, if you are here for this application, if you could please raise your hand. Let's see. Hold on one second, I'm just going through the chat. All right, so we do have a lot to go back to for Park Heights now here. All right, Carissa Cutlet is here for 27 Gems, and then we'll go back to the auto.
Sure.
All right. My chat just didn't populate for me. Sorry about that. All right, so Ms. Cutlet, you are unmuted.
Hello, thank you. I have.
Go ahead, ma'am.
I was going to say I have no further comments to add.
Very well. You preempted my question. In that case, the board having heard your appeal, we believe we have sufficient information to approve your appeal. Thank you so much.
Thank you.
All right, so it looks like we do have people here for Park Heights.
Okay.
So,
Recalling. Yeah.
So, yep, go ahead.
All right. Recalling case 2021-298, 4128 through 4136 Park Heights Avenue. The appellant is Deepinder Singh Gill, and whoever we have will take.
Okay, so it looks like Mr. Gill is here and he's unmuted, and it looks like we have people here, I think both in support and possibly in opposition, which is good because now we've kind of come to the end of the consent docket. So we'll start with Mr. Gill. Mr. Gill, you're unmuted, sir?
Yes.
Well, the question is, if we have opposition, then I'll need a little more than just if he has anything to add. So.
We have President of Park Lane here in support. we have, let's see, I think we're okay. I think there might be a question of the applicant, but I don't think there's necessarily opposition.
Okay, so I'll ask you, Mr. Gill, is there anything you'd like to add to your application at this time?
No, sir.
Okay. Do we need to hear from an individual, Katie, or can you discern it based on what you're looking at?
You're muted, Katie.
Mr. Gill, can you hang on with us 1 second? I'm gonna unmute Miss Jiggets. Hold on 1 second. Hi, Ms. Jiggets. Or were you here in support or in opposition of the application, or did you just have a question?
I have a question for the planning department, just for clarification.
Oh, sure.
Okay.
On the BMCA site, the history online, there was this letter submitted December 21st, 2021, that indicated that the planning department recommended disapproval of the application. Did something happen since then? That's just what I wanted to just get the update.
Yes. The memo you're referring to was based upon the original application for this property, which called for automobile repair and body shop. And the body shop portion of the use is something that is not allowed in that area. And it would therefore be a non-conforming use. However, the last authorized use of the property, which is also non-conforming, was for automobile repair, but not with a body shop. So when the application was amended by this applicant as of a day or so ago, then the department no longer had a reason to object to the proposal.
Okay, thank you. So just for clarification, can you just restate what the approved use would be just for an auto shop?
Motor vehicle service and repair minor in a fully enclosed structure, which is what its prior authorization was, and which is what it continues to be.
Right, and I'm only asking because we in the community know that it was more than that. So I just want to, we're not opposed. The applicant came to the community, but now I have different information. And now I understand since it was just a couple of days ago. But what does that actually mean for us visually? Does that restriction or clarification that it's an auto shop minor repair mean that all cars have to be indoors? I just want to make sure I'm clear as well on that part.
Means specifically all work has to be done indoors. Obviously, vehicles awaiting service and vehicles which are being serviced but not yet picked up by their owners can be stored outside of the building. But the actual repair work, whatever it may be, has to happen inside a fully enclosed structure.
And let me see, I think I can, if you give me 1 second, I can read the definition for you. So motor vehicle repair minor is repair and replacement of cooling, electrical, fuel, exhaust systems, brakes, wheel alignment, balancing, repair and replacement of shock absorbers, replacement of mufflers, tailpipes, hoses, belts, things like that. So what Mr. French was saying, like the large body work, that would be auto repair major, and that could not be done here, which is why they removed body work from it and just put auto repair minor. So as he said that, like the work has to be done inside, but cars obviously can be parked on the lot, can be waited to pick up, dropped off, and rotated through. And just for clarification, Ms. Jiggets is with Park Heights Renaissance. So I forgot to announce that at the very beginning.
Thank you, Katie. And just, I don't have an opposition per se, but I do want to put a comment on the record. Is that allowable?
Go ahead, ma'am, if you like.
Yep, I just want to make sure that the sentiment is known that while we support the auto repair and want to work with the owners, we just want to have consensus that the vehicles will not overflow in a way that has been a nuisance to the community in the past.
Hopefully the applicant takes that into consideration. If there is a nuisance issue, then certainly the remedies are available to the community associated with that. But, you know, unfortunately, we don't control the nuisance regs and the enforcement of that. So we are just here to grant an application if appropriate, and we found that. So your comment is noted for the record, and I'm sure that Mr. Gill has heard the concern. So I think that's where we are. Thank you, ma'am.
All right, thank you.
Thank you.
Mr. Gill, the board having heard your appeal, we believe you have sufficient information to approve your appeal.
Thank you, sir.
Thank you. Let's see.
Yep,
Do we
so
have-
in the chat, we had, let's see, I think Ms. Jiggets was the only one that needed that clarification, but we had additional support for that application in the chat.
Okay, that's fine. And okay, do we want to try to go before going to that concludes the consents, other than the ones that we had to jump over, right?
Right. Let's
Any
see.
want to try to raise somebody up for Crescent?
I asked, let's see, I'm gonna unmute Roxana to see if she had any success reaching them. Roxana, any success reaching anyone for Crescent?
No, I did not. Will you want me to send him like an email or something? Because I just left him a message.
Okay. Yeah, if they didn't respond to their voicemail, more than likely they're not going to respond to their email. All right, so well, thank you. All right, I can go through the call-in users and we can try one more time for Crescent. If not, they'll have to get themselves back on the docket sometime.
Sure.
All right, so we'll try call-in users again. This is for 2021 282 and 2021 283, 921 North Crescent, 923 North Crescent. I'm going through the call-in users. All right. Going to the next caller. Going to the next caller.
I'm Scott. Better than I did on the. But anyway, let's not.
Nope. There, and then this is the last caller. All right, so that's it for Crescent.
Okay. Put that back on the docket at some point. So, all right. So now we're on to the regular docket. We have one matter on that docket, and that is case number 2021-300, 714 Berry Street. Adam Carvalho is the appellant, and this matter addresses variances to continue with 2 dwelling unit use, lot area, and parking. And I'll hear from planning and staff.
Thank you. Planning Department reviewed this application. The information available to the department from the portion of the permit system that the department has access to notes that in 2004, the current owner of the property applied for and received a permit for electrical work in the existing building, at which time use of the property was noted as single-family dwelling. The electrical work does appear to have been something that could have facilitated use of the property as 2 dwelling units. However, the owner did not seek or receive a use and occupancy permit for a multifamily dwelling at that time or following completion of the electrical work. Therefore, this application actually requests approval of a conversion of the property from a single-family dwelling to a multifamily dwelling. The property is located in the R7 zoning district, and in that district, the board is not authorized to approve residential conversions. Therefore, the department recommends disapproval of the application because the zoning code does not authorize the board to approve conversion of a single-family dwelling to a multifamily dwelling in the R7 zoning district where this property is located. Thank you.
Thank you, Mr. French.
Okay, sorry, we received pictures from the applicant, so I was just trying to open them so that I will be able to share, and we got those recently. So I have Adam here, and I also have Nate. So, Adam, are you gonna be speaking on behalf, or is Nate gonna be speaking on behalf of the applicant?
I can start and Nate can fill in afterward.
Okay.
This property,
Wait, Adam, I'm sorry, I never gave the staff report on this. So sorry, I was too busy trying to do 6 things at one time. So where we are with Berry Street is, if the board recalls, we had this one before, and Mr. French also made the same statement, and we also wanted to do additional time to do research on the staff end. In the permit system, the land use code does identify it as a single family dwelling. So what we try to do is make a determination. We backstop that to look for the land use card. The problem is there's no land use card for this particular property. So I can't verify in city records for sure if this is a single family dwelling or if it's a multifamily dwelling. I think everybody on this panel has seen this happen before. When we've gone back, we've seen evidence come before the board regarding how it's constructed as 2-family. And when I'm able to find the land use card, it verifies that. But then sometimes the land use code is in contradiction. So we've made a determination as far as staff here is that we need to see the land use card to verify the last legal authorized use. So at this point, we don't have that. So there's nothing in the record other than, as Mr. French said, that the land use number identified, or the land use code, underlying land use code identified it as a single family dwelling. So we postponed it to allow the applicant time to provide evidence to the board that it was indeed a legal 2-dwelling unit. So sorry about that, Mr. Carvalho.
no issue. So this property is the current owner is in his early 90s. He has owned the property for approximately 50 or 60 years. When he purchased the property, according to his estate, it was a 2-unit at the time of purchase. The gentleman is currently in hospice right now, and my client is actually purchasing the property from this gentleman, and they're actually having to go through a conservatorship to actually purchase the property from, because the gentleman himself is not capable of speaking on behalf. That's why we don't have an actual official statement from the current owner. But according to his son, who's in his maybe 60s or 70s, according to him, when his father bought the property 50, 60 years ago, it was actually a 2-unit. Those obviously predate current records. We have physical evidence that there are, in fact, 2 electric meters, 2 gas meters, 2 hot water heaters, 2 front doors to the property, 2 kitchens, and it was enjoyed and used as a 2-unit for the better part of 50 plus years. The property is currently vacant, and I think Nate kind of elaborated on that. I believe the owner lived in one of the units maybe more recently until he was relocated to hospice, and his health health took a turn for the worse. But we are simply just asking for, we want to try to make this sort of a legal 2-unit, as it was, previously not documented, or but it has been enjoyed as a 2-unit for quite some time. Perhaps Nate can kind of fill in any gaps that I left.
I made him a panelist as well, and he's unmuted. And Nate, I do have the photo. So if you want to speak, I can try to share those with.
Yeah. And I also have photos and drawings as well, if that's helpful to share too.
Oh, okay. Yeah. If you have what Nate sent me, I'm happy to pass the ball to you.
Okay.
Well, I have a few words here, if this is the right time, Ms. Byrne.
Go ahead, Nate.
All right, great. Thank you, Mr. Chair. Nate Prettle, I'm here with Adam Carbala on behalf of the applicant. And Adam, I think, did a pretty good job of summarizing the evidence that we have. And again, that's 2 BGE electric meters, gas meters, 2 water heaters, 2 distinct and separate entrances. And I'll speak to the permit that Mr. French mentioned before. Do that. In my experience on these things, you'll see all sorts of cases of whether or not it's 1, 2, 3 units. But typically, when you have the infrastructure from the utilities, whenever those are first put in, they typically require some sort of evidence from the city here. And I acknowledge this is a difficult case because there's no evidence that shows one way or the other. My guess regarding the electrical permit is, and why that would say 1 dwelling unit, because the structure itself is clear that by the fixtures, the finishings, the appliances there, this has not been touched in a generation, and I think it's clear that this has existed in this configuration for quite a while. But my guess about the permit is a contractor filed it, and just the easiest thing to do is just put a single dwelling unit, or they don't know, and I don't know that is evidence in itself. It was a single family, because when I walk in it, and same with Adam, it's 2 units, and the shape, the sort of condition that the property is in, it's clear that it's been that way for a long time. So when I look at this, it passes the eye test. It's got the utility connections, and we have we were going to provide a affidavit from the current owner, but I think right after our clients put this under contract, Adam mentioned some of the health problems, and he is in hospice and unable to communicate. I know that if necessary, we could get an affidavit from the conservator, stating that this has been 2 dwelling units in this configuration since the time of purchase, which again, 50, 60 years, would have predated the 1971 zoning code as well. And so I'm happy to answer, any questions, regarding that. I'm not surprised if the owner, did not keep up with any other records or anything, because, someone in his position, why would they, in terms of, rental licenses. I do not know, who else would have been living in one of the other units. But as Adam mentioned, 2 kitchens, 2 separate distinct entrances. And so that's basically what we have. I'd urge the board to approve this. If we need to get an affidavit from the current owner's conservator, if you need to make that a condition, we can certainly do that. I'm not necessarily asking you to do that, but if that's, the board needs that to find, what they need to approve it, we would be willing to do that as well.
Right, and I think that there was a question that Martin asked about multifamily dwelling licenses. So just for the board's information, prior to 2019, 2 dwelling units did not require a multifamily dwelling license. It was 3 or more that threw you into that. In 2019, when the law changed, then you did have to get a rental license for 1 unit, 2 unit, as well as multifamily. But if this property has been unoccupied, or only 1 unit has been occupied since 2019, then there would be no need for a rental license. So it's, like I said, we looked for that too, but there was no legal requirement for 2 units to have a license prior to 2019. And again, if only 1 was occupied and it was owner occupied, then there was no need for a license. So Adam, do you want to share the photos, or do you want?
I'm having difficulty. I got a new
I'll do
laptop.
it.
My settings are all messed up. But yeah, if you can share them, that'd be great.
I'll take the ball back.
Okay.
Let me see if I can do this. Here we go. All right, so this is the first one. It says, looks like meter number 2. Can you guys see that?
Not yet.
All right.
Not yet.
It would help if I push share. How about now? So can you kind of see the whole screen where we have a series of photos?
Yes.
All
yes.
right, so this one looks like a meter. It says second. This next one is another meter. It looks like it says first down at the bottom. There's a bit of a shadow. There's another photo though that shows both. So we've got first floor, second floor. What is this, water?
Those are gas meters.
Gas. You would think I would know that. All right.
And you can kind of clearly see that entry vestibule. You have one door directly in front that leads to a staircase that goes up to the second floor unit, and that second door immediately to the right goes in that accesses the first floor unit. So there are two distinct front doors via a shared vestibule that lead to two separate dwelling units.
And then again, I guess same gas unit or gas meter.
This way you can see the two electric meters, and there's two electric panels as well to support each one of the individual electric meters.
Either Mr. Carballo or Mr. Prettle, can you tell us how far back the BGE bills go for the property?
So, Mr. Chairman, and Adam, if you have something, please jump in. But that's something we have been looking for, and because of the health conditions of the current owner, we've been unable to obtain them. But we just don't have any records. But we assume the fact there's two BGE meters, there's two BGE bills. And I can certainly look into that, but it's been a challenge to get some of this stuff that I would usually come with because of the condition of the owner.
All right.
And here you can see two gas-powered hot water heaters, each serving individual unit, each individual unit.
And I think that was it for the photos.
Okay. All right. Any additional questions of the applicants from the board at this point?
No questions.
All right.
Let's see if I can get out of the share. Stop sharing. There we go. Okay.
Okay.
And I don't think we had anybody else in support or opposition. I don't see any hand raised. I don't see anything in the chat. But since this is the one and only case on the contested docket, I'm going to go through the call-in users one more time. So again, if you are here about 714 Berry Street, which is 2021 300, please speak up. Go to the next one. And then the next one. And now the last call-in user. Okay, I think that's it for, let me just check one more thing here for Barry. That's it.
Okay.
Thank you, Ms. Byrne. Thank you, Mr. Chair.
All right. Thanks, gentlemen, for your presentation.
Thank you.
That went up. Okay, so have we concluded the docket at this point? Okay.
Yes, so we still don't have a response from Crescent, but that is everything on the docket.
Okay. So we'll proceed to deliberations then.